On this episode of Law Weekly, we bring you some of the early reactions trailing the judgment of the Presidential Election Tribunal. We have the views of two senior advocates of Nigeria. Also showing on the program, more from the recently concluded Annual General Conference of the Nigerian Bar Association, plus a recap of the top trending stories from the news. Hello and welcome to the program. I'm Shola Shieli. On Wednesday, September 6, the Presidential Election Tribunal finally delivered the long-anticipated judgment in 3 petitions filed before it to challenge the return of President Bola Tinubu. Let's bring you some of the excerpts from that judgment before we take some of the reactions trailing it.
Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than 2 candidates, as in the instant case. Not majority of votes cast as propounded by the petitioners. The first respondent was therefore ripe from the result declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, the 4 issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the 3 petitions, number CA from PEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-23 are all devoid of merit, the petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected President of the Federal Republic of Nigeria. The parties in the 3 petitions are to bear their respective costs.
Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or that it is difficult to prove the same petition. In the instant case, the petitioners' pleadings were deficient, while they complained of non-compliance with the Electoral Act against first respondent. Their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment.
Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW 12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW 12, the petitioners exercised that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence.
And for those who, like the petitioners, are enamored by the now very familiar patronizing judgments passed on elections, regularly passed on elections, by European election observer missions every 4 years. Even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020 presidential elections of the United States that saw him out of office was also a fraud, it may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read above, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough.
It is clearly evident that the decisions in Exhibits X1 and X2 tendered in the two petitions, respectively, as well as the decisions of this court in appeal number CA-LAG-CV 332-2023, APC versus Labour Party and 42 others, have dealt a death knell to the petitioners' contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines for conduct of elections 2022 mandatorily required to electronically transmit election results to the collation system and to INEC result viewing portal, which is the RF. Apart from this fundamental deficiency, which I have highlighted, the lead judgment just delivered had exhaustively considered all the other issues and rightly concluded, in my view, that the petitioners in petitions number PAPC 03-2023 and CAPEPC 05-2023 have failed to establish all the allegations contained in the two petitions. I adopt all those reasons and conclusions stated therein and also find the two petitions devoid of merit.
Now, there's been so much reactions that has greeted that judgment. Two of the three political parties, talking about the PDP and the Labour Party, have indicated their resolve to challenge the judgment on appeal. Lawyers have also been commenting on the judgment. We have the reactions of two senior advocates up next.
I think the judgment reflected what was put before the Presidential Election Petitions Tribunal. Their lordships were very calm in analyzing the case that were brought by the different sets of petitioners. So you have a clear picture that they took their time in identifying the issues raised by the petitioners for determination and the objections that were raised by the respondents to the issues raised by the petitioners. At the end of the day, you have a sense that their lordship did justice according to law in respect of the issues submitted for determination by the parties. So I do not think there will be controversies. People may accept the decisions, and people may say, no, let's test the decision at the appellate court, this time the Supreme Court of Nigeria. It is within their rights. But the most important thing is that their lordships accredited themselves nobly, took time in identifying the issues, discussed them, and came to their conclusions. It is important that a judgment is meant to address issues that are raised, not outside the court or the tribunal, but within the precincts of the court or tribunal. So unless there is contrary view that the issues that were determined by the tribunal were not those raised by the petitioners and the respondents in answer to the petition by way of objections, and you could see that there were several rulings in respect of the various objections and issues that were raised. But because the electoral law has made it such that all interlocutory rulings should be taken together with the final ruling so as to save time and so as not to unnecessarily delay the trials. So you can see that all those rulings were taken before the final judgment in each of the three petitions, 3, 4, and 5, in respect of the 2023 presidential election. So to me, the judgment reflects from what I listened to, the issues that were brought before the tribunal for determination. I don't think the judiciary was under pressure. This is not the first proceedings that the judgment has been streamlined, but I think because they knew that a lot of ulabalu has been put in the public space to try to paint the judiciary as being under the authorship of certain particular sets of people. And if you look at the pedigree of their lordships, impeccable. If you listen to the diction, the language, the erudition, the sense that the judgment made, you know that they were not playing anybody's game. They were writing their names in the sands of time and history in this country. And when you look at the precedents that the judges referred to, you cannot fault them. You cannot. The Supreme Court may hold a different view, and the Supreme Court may agree with them, either in totality or by division of the Supreme Court. But what is important is that they have done justice according to law as they see it based on the facts presented to them. And some of my very senior colleagues, senior SANs, in the matter, their cases were cited. Even the books by the Reverend Chief Chris Uche on these matters were cited with approval. The law is settled on most of these things, almost all, except maybe one or two gray areas. But then the judges have to come to a decision. They cannot sit on the fence. They have taken a decision according to the law, as they see it, and based on the facts.
I received the judgment with some measure of satisfaction. Satisfaction, not necessarily because of the way, not necessarily because of the outcome, but more particularly because of the way and manner the image of the judiciary was redeemed by the transparency of the process, so that people are able to see how the judice actually works. That the judice works based on facts, based on evidence, based on the element of proof, based on findings, based on law and legal principles, based on standard of proof that you need to meet before you can succeed in an action. And arising from all of this, based on legal conclusions that could be drawn from facts and evidence adduced. So the transparency of the process, for me, is the icing on the cake, because the local and international audience were able to see how the judice works and how they arrive at their conclusions. So what you can, is either you want to agree with the conclusions reached at the end of the day by the judice, or you want to disagree with the conclusions reached. And if you agree with the conclusion reached, then there will be no need for appeal. But if you disagree with the conclusions reached, of course the option is also available for you to proceed to the Supreme Court, which is the highest court of the land, in order to test the veracity of the findings as well as the conclusions reached for the benefit of our collective jurisprudence. I'm not one to condemn any of the parties. I'm not one to condemn the petitioners for going to court, because that is consistent with the democratic tradition. That is one of the options available to a litigant in a democratic environment. And it shows the civility, it shows the decorum of those who approach the court. And for the benefit of the judiciary too, it also enhances the quality of our jurisprudence. We now know how our judges think, the state of our law as far as our electoral jurisprudence is concerned. So Legal practitioners can take benefit. Law lecturers can take, benefit. Law students can take a benefit. And the administration of justice generally can also take benefit. Because public confidence is restored. Public confidence is enhanced. And that we now know that you don't win cases on the basis of sentiments. You don't win cases on the basis of beer parlor gossips. You don't win cases on the pages of social media. You understand me? You also don't win cases based on hearsay. You need to adduce evidence, incontrovertible, cogent, compelling evidence. Whether the evidence you now adduce is sufficient is for the judges to decide. You see, the beauty of it is that the judges can err either on the side of facts or can err on the side of law. And if any of that happens, then you can go on appeal. You don't embark on street protest. You don't embark on violent demonstration when you have the option to exhaust. And that is, for me, the beauty of what transpired.
Thanks for staying tuned. We turn our attention now to the just concluded annual General Conference. The President of the Bar has been speaking about the medical outreach, which was organized in partnership with Moses Lake Medical Team, University College Hospital Ibadan UCH, Garki Hospital, the Medic Cancer Foundation, and the Kebbi State Government as part of the activities of the just concluded 2023 Annual General Conference.
This administration of the Nigerian Bar Association wants to reset the mindset of members of the legal profession. So when we talk about providing leadership for the people of this country, nobody is going to accept you as a leader until you show to that person that you care and that you genuinely care for him. Because people are not interested in how much you know. For all you care, you can go to court, speak all the grammar. They don't bother about that. What they care about is how much you also care for them. And so what we are demonstrating as people who are privileged to provide leadership to the country is to tell Nigerians that we care for you and we genuinely care. I mean, if you've been here in the last couple of days, it was a beehive of activities. People came from across the country. I saw a lady who came from Katsina who had knee replacement on both legs. All manner of surgeries. We had over 100 surgeries that have been carried out already. Thousands of patients have been seen, both lawyers and non-lawyers. We have UCH, University College Hospital, also supplying their support, volunteers that came. We have orthopedic surgeons. We have also members of this Moses Lake Medical Team from the South American country of Chile. We have pediatric surgeons there. We have urologists. We have general surgeons. We have nurses. We have dentists that came, and it's been awesome. We've done cancer screening exercise free for lawyers and for non-lawyers as well. Cervical cancer and mammogram for our female colleagues and non-lawyers, and also prostate cancer for over 600 of our colleagues. And you know, the fight against cancer is one fight that is successful by easy detection. Once you subject yourself or you avail yourself the opportunity to conduct tests early enough, then you are able to deal with it. So why MBA is because we want to demonstrate to Nigerians that we are really, really primarily called to lead the people, give direction to the people, and advance the cause of this nation. Health is wealth. A healthy country is a wealthy country. And anybody who you have shown compassion for, that you go out of your way to get supply of medical interventions for him, when you come to doing his own case as a lawyer, you are not likely to be unethical and be unprofessional about it. So, it's a whole lot of repositioning that we are doing as for members of the legal profession, and also letting the public know that we are in position to actually command their respect, so that whatever we do as lawyers, would be acceptable to them. So these are primary reasons why we decided to do this. And it's the first time that this is happening in the Nigerian Bar Association. There is a lot that we can achieve in volunteerism. It's a spirit that we need to catch in this country. And we cannot leave everything for government. We as private individuals, we as organizations, we as members of the elite society in this country that have been privileged, to be educated, and we are given positions of privilege in the society, we can actually give back a lot to the society. So that is what we are doing. We're happy doing it. This is my most rewarding moment. As a lawyer, I tell you, I have more patients calling me now to talk to me than my clients. And my clients is the most rewarding moment. This is a good ground to sow. If you sow your seed here, you will sure have a bountiful harvest. And I will use this opportunity to call on all my professional colleagues, other professionals in this country, those who have the means to come and support a cause like this. We would continue to do it. And like I said, every opportunity we get, we'll let people know that there is something like this that we can do to help people in this country. And you can see my stethoscope. I am now the Chief Medical Director of the MBA Specialist Hospital.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtroom.
We begin with the report that the Kogi State Election Petition Tribunal has nullified the election of Senator Abubakar Ohere as the winner of the Kogi Central senatorial election. The court declared Ms. Natasha Akpoti Uduaghan as the actual winner of the February 25 senatorial election. The chairman of the tribunal, Justice Kemakolum Ojaiko, read the unanimous judgment of the three-man panel. Justice Ojaiko said Senator Ohere's results were inflated in 9 polling units of Ajaokuta local government area, while that of Ms. Akpoti Uduaghan was intentionally reduced in the areas by the Independent National Electoral Commission, INEC, as well as 3 other polling unit results that were deliberately not entered for Ms. Akpoti Uduaghan in the same local government area. After making the proper corrections, the court declared Akpoti Uduaghan of the People's Democratic Party, PDP, winner of the poll, having scored 54,074 votes, against Senator Ohere of the All Progressives Congress, who scored 51,291 votes. In the governorship elections in Ogun State, parties in the petition instituted by the Ogun State chapter of the People's Democratic Party and its governorship candidate, Ladi Adebutu, in the March 18th governorship election have adopted their final written addresses. The governorship candidate had approached the three-man tribunal headed by Justice Hamidu Kunaza to challenge the victory and declaration of the state governor, Dakwa Abiodun, by the Independent National Electoral Commission, saying that the election was marred with corrupt practices and non-compliance to the Electoral Act. In their submissions, counsels to INEC, Governor Dakwa Abiodun, and the third respondent, the All Progressives Congress, argued that the petitioner failed to present his case beyond reasonable doubt. They asked the court to dismiss the petition for lack of merit. The court chairman has, however, adjourned judgment to a date to be communicated to the parties in the petition. Away from the tribunal, the Federal High Court sitting in Lagos has ordered parties in the suit filed by 3 aggrieved shareholders of First Bank against First Bank Nigeria Holdings to file written addresses on whether the court can proceed with the hearing of the matter despite the pendency of an appeal. Justice Akintayo Aluko gave the order after he notified the lawyers that the appeal instituted by First Bank Nigeria Holdings PLC before the Court of Appeal is seeking a review of the restraining order granted by Justice Nicholas Owibo, stopping the annual general meeting of First Bank Nigeria Holdings, which was held on August 15, 2023. Apart from the appeal seeking to stop the annual general meeting of the company, First Bank Nigeria Holdings had also filed another application seeking a stay of the proceedings. And we round up with the report that proceedings has resumed in the coroner inquest into the circumstances surrounding the cause of death of a 12-year-old student of Darwin College, Lekki, Sylvester Oromoni. After a long break, the coroner, Magistrate Mikhail Kadiri, who is sitting at the Magistrates Court in Ogba, Lagos, invited the mother of the deceased to appear in court to give her evidence on Monday, September 11. Law Weekly learned that her testimony will center on the cause of death and the statement she made to the police, after which parties will file written addresses and the coroner will give his findings and conclusions. 2 students of the college who had earlier testified have, however, given their testimony afresh. The testimony was given behind closed doors to protect the identities of the minors.
And that's the program for today. If you missed any part of it, you can find it in past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shoyele. Thank you for watching and see you next week.